Thank you, Mr. Chairman, and it's always good to be back in this House. I had the privilege some time ago of representing the state of Florida in this House. Today I want to emphasize that I'm here today representing no one but myself. I'm speaking solely for myself. Furthermore, I'm here today not to speak on issues of policy, but on issues of law, specifically on issues relating to international trade law under the WTO treaty. And I believe I've been invited here today because when I became a former member of the House, I went to Geneva and became one of the 7 founding judges on the appellate body of the World Trade Organization, and I served for nearly a decade there, including 2 terms as the chief judge there. I have written quite a few WTO legal opinions. So that is why I'm here today. I'm here because largely overlooked in the emerging congressional debates so far about restricting exports of natural gas is the possibility that such restrictions are inconsistent with the obligations of the United States to other members of the WTO under the WTO treaty. This matters because if our restrictive energy measures are inconsistent with our treaty obligations, the United States risks losing a case in the WTO. And such a loss could cause the WTO to authorize expensive economic sanctions against us through the loss of previously granted concessions in other sectors of our international trade. Mr. Chairman, WTO rules apply to trade in natural gas and other energy products in the same way they apply to other traded products. Some have suggested that energy products are somehow separate and apart from other traded products in how WTO rules apply to them. There is no legal basis for this view. Among WTO rules that bind us in the WTO treaty are rules prohibiting bans, quotas, and other forms of quantitative restrictions on exports unless those restrictions take the form of export taxes. Now, as all the members know, taxes on exports are prohibited by our Constitution in the United States, so energy export taxes are not an option for us. WTO rules also permit temporary restrictions on exports to prevent or relieve critical shortages of essential products, but that can hardly be said to apply to our current situation with respect to supplies of natural gas. A number of legal concerns occur when considering the consistency of the current U.S. process for licensing exports of natural gas with WTO rules. First of all, the current U.S. process gives special treatment in licensing exports of natural gas to countries with which we have a free trade agreement. Natural gas exports to these countries are deemed to be in the public interest and permitted without delay. In contrast, the Department of Energy has elected to subject licensing requests for LNG exports to non-FTA countries to a thorough and lengthy assessment intended to determine whether exports of natural gas to those countries serve our public interest. In this way, applicants that ship LNG to FTA countries are preferentially given expedited review in the licensing process as compared to those applicants that will ship LNG to non-FTA countries. When seen through the prism of WTO law, Mr. Chairman, these are measures affecting trade that result in discrimination between like-traded products. The legal question under WTO law is whether this discrimination can be excused by an exception in WTO law that allows trade discrimination as part of a free trade agreement. But it is not at all clear that all of the FTAs of the United States fit within the definition in the WTO treaty of a free trade agreement. Fortunately, H.R. 6, introduced by Congressman Gardner of Colorado and currently under consideration by this committee, would eliminate this potential legal concern by providing that natural gas exports to all other members of the WTO would be deemed to be in the public interest. Depending on how the Department of Energy chooses to implement H.R. 6, however, it may not in its present form remedy several other legal concerns arising from the current U.S. licensing process under WTO rules. I frankly could not tell from the testimony earlier today by the representative from the Department of Energy how precisely they view this bill, how they would change what they do if this bill is enacted, or even how they engage in their process today, nor can really anyone else. One remaining legal concern under WTO rules is the question of the lengthy delays in granting export licenses. H.R. 6 in its third paragraph would provide for immediate approval of pending applications, but what about new ones? Under WTO rules, a license can clearly be a restriction on exports, and case law has defined the notion of a restriction broadly to include licensing procedures that pose limitations on actions or have a limiting effect, such as by creating uncertainties or by affecting investment plans. In one case, delays of up to 3 months in issuing export licenses were found to be inconsistent with the rules. Now, to be sure, liquefied natural gas is practically speaking not just another widget. Before it can be shipped by sea, natural gas must be transformed in a careful way that requires special facilities. Some period of deliberation in siting and evaluating LNG facilities seems reasonable. The FERC process of environmental consideration is probably perfectly defensible under WTO rules. But what would WTO judges be likely to say about delays in issuing export licenses that last much longer?
Mr. Bacchus, I've let you go a couple minutes over. If you would just summarize. And
let me make one more point, Mr. Chairman, and then I'll be happy to answer questions of the members on these other issues. And I congratulate the committee on asking first about our WTO obligations before enacting legislation rather than finding out about them later in Geneva. An additional remaining legal concern is the lack of clarity in how the Department of Energy defines the public interest. Conceivably, even lengthy delays in the licensing process could be excused under WTO rules if it could be proven by the United States that such delays are necessary to protect life or health or are related to the conservation of exhaustible natural resources, so long as the process is not applied in a way that results in arbitrary or unjustifiable discrimination or a disguised restriction on international trade. Now, here's my final point, Mr. Chairman, for now. If, however, in determining the public interest, the DOE considers as a factor the effect the proposed exports will have on domestic producers that use natural gas in making their products and their competition with like foreign products, then these exceptions to WTO rules will not be available and will not excuse a WTO violation caused by lengthy licensing delays. In fact, Mr. Chairman, the United States of America has been making precisely the point that I have just made just now in a case against China in the WTO dealing with Chinese restrictions on exports of rare earth elements. Most likely, the United States will win this case. A WTO panel ruling is expected tomorrow. If we've proven the facts, we will prevail on the arguments I've just made that are some of the same arguments that we heard earlier today.